Good morning, everyone. I am Antonio Emmanuel. I am the Secretary to the Judicial Education Institute Committee, and I'd like to formally welcome you all to this year's Judicial Education Institute Week 2024. I'm about to begin by reading the official protocol list. Good morning to the Honorable Chief Justice Mabel Ajaman, Chairperson of the Judicial Education Institute of the Turks and Caicos Islands. The Honorable President of the Court of Appeal and Vice Chairperson. The Honorable Mr. Justice Grishaw, Member of the JEI Committee. The Honorable Rondalee Braffett Knowles, OBE KC, Attorney General of the Turks and Caicos Islands. The Philip Bennett KC, Director of Public Prosecutions of the Turks and Caicos Islands. Your Lordships and Honors, the learned members of the Bar, distinguished faculty, distinguished stakeholders, distinguished participants. Welcome to Judicial Education Week 2024. Before we begin this week, I'd like to ask Ms. Monique Harvey to lead us in a prayer. Ms. Harvey.
Good morning, everyone. May we bow our heads, please? Dear Heavenly Father, maker of all mankind, we come before you this morning, petitioning you so that we may obtain the graces we need to exercise what is required of us in our various capacities. We present to you our executive body, our Parliament, the Honorable Chief Justice, and the entire judiciary of the Turks and Caicos Islands, our relevant stakeholders, and our various presenters that will be engaged in this Judicial Education Week of 2024. Hebrews chapter 4 and 16 declares, "Let us therefore come boldly to the throne of grace, that we may obtain mercy and find grace to help in the time of need." We pray for the integrated and holistic nature of our health and well-being so that our body, mind, and spirit would align itself to be able to carry out this great task that is before us. Cover our judges, O God. Clad them in your wisdom so that in their decision-making, they will continue to uphold the law and at times, if necessary, be quick to listen, but slow to speak, not having any bias or prejudice. We pray that the handing down of judgments would be proactive and beneficial to our society while rendering what is a fair and just outcome of an action. We pray for good representation and protection of those who cannot protect themselves. For your word says, "Inasmuch as ye have done it unto the least of these, ye have done it unto me." May we not grow weary in our well-doings. And finally, we place our presenters in your hands. May they rise now to this occasion, as they have done aforetime, to engage, to impart, to collaboratively strengthen stakes, exchange knowledge, as we strive for a new day and a brighter future. May the God of grace, mercy, and favor be our portion, both now and forevermore. In Jesus' name we pray. Amen.
Thank you very much, Ms. Harvey, for that very soulful prayer. But now I'd like to ask the Honorable Attorney General to deliver brief welcome remarks. Honorable Attorney General.
Good morning to our Honorable Chief Justice, Mabel Ajaman, Chairperson of the Judicial Education Institute, and other distinguished members of the JEI, and other distinguished persons, including the presenters and other persons present, and colleagues at the bar. It is a privilege to have been asked to bring brief remarks at today's ceremonial opening, marking the opening of this year's Judicial Education Week. Continuing legal education is an important aspect of ongoing professional development. And the JEI is to be congratulated for leading the way and setting a very high standard for this jurisdiction. The list of interesting topics are relevant to the work that we do, and we also look with interest at the areas of development that are covered in the list as well. We congratulate the organizers of this week's activity, and we certainly look forward to the week ahead. Many congratulations.
Thank you very much, Honorable Attorney General. Hi, good morning, everyone. So sorry about that. We have a bit of technical difficulties on our end. I was just saying thank you very much for those words, Honorable Attorney General. I'd now like to ask the learned DPP to deliver some brief opening remarks. Learned DPP.
Honourable Chief Justice and other distinguished people who are present. The day one of what is going to be an extremely interesting programme with topics relevant to all. In the short time I have to address you, I considered what should be said, and I'll just read one quote. Education is our passport to the future, for tomorrow belongs only to the people who prepare for it today. Thank you.
Thank you very much, learned DPP, for those words of deep wisdom. I'd now like to ask the Honourable Chief Justice to deliver formal opening remarks. Honourable Chief Justice. Good morning, Honourable Chief Justice. Your microphone is muted.
Sorry, I was saying thank you to you, and I was importuning persons present that if you're not speaking, could you please go off camera to save the bandwidth? Please go off camera if you're not speaking right now. Thank you. May I adopt the protocol established and wish you all a very good morning. Distinguished guests and participants, as the expression goes, knowledge is power. To that cliche, I will add that in general terms, the application of knowledge to any endeavor produces informed, effectual, and more particularly in the justice system, it may be true to say that judiciality and law enforcement officials may be a lack of knowledge in pertinent areas of the law, especially in emerging areas driven by the electronic age and all it has brought in its wake, will produce an ineffectual justice system, insignificant, irrelevant, and in which the public will have no confidence. It is therefore not surprising that in the Commonwealth Latimer House Principles of Judicial Conduct document, which provides a roadmap to accountability and excellence, judicial capacity building is identified as key to viability and effectiveness in justice delivery. This is why it is important for every judiciary to provide for the periodic training of judicial officers and judicial staff. It assures greater efficiency in the work of the courts and the effectiveness of the judicial institution as the fulcrum on which democratic governance turns. In the Turks and Caicos Islands, the Judicial Education Institute provides training programs, not only for the judiciary, but also for its stakeholders. It is our firm belief that if we work together with our stakeholders, we will thrive together, and the society we exist to serve will be the better for it. So we have since 2021 run a training calendar which taps expertise in the country, around the region, and from distant shores to provide necessary information for the more efficient and effectual performance of our duties. We also operate a website, judicial.tc, where we provide for learning. Our flagship program is a celebration of learning and new ideas at an annual festival which we call the JEI Week. It has its inception being a virtual festival. We are confident that at JEI Week 2024, the Turks and Caicos Islands judiciary and its stakeholders at home and abroad will, with the diverse offerings, collectively engage in the pursuit of legal learning and professional development. Motivated by the desire to move practitioners of the law into the era of modernity to retain relevance and ensure significance, we hope to acquire a broad knowledge base of especially new and emerging societal issues and developments as we improve our collective understanding of the ever-evolving legal landscape. JEI Week 2024 promises an exciting time with a lineup of distinguished presenters. I am in no doubt that we can expect a week of insightful discussions and invaluable knowledge exchange. I thank our esteemed distinguished faculty for making room for us, graciously agreeing to share knowledge, who continue to support the judiciary and to partner with us at this annual event. I now officially declare JEI Week 2024 open. Our first presenters for day one are Justice Isabel Ferrari from Brazil, who will present on artificial intelligence to give us some insights. She will be followed by His Honor, Mr. Sunil Sukraj, Chairman of the Environmental Commission of Trinidad and Tobago, who will present on environmental issues. They will both be further introduced by Mr. Antonio Emmanuel, Secretary to the JEI. I thank you all for your attention.
Thank you very much, Honorable Chief Justice. Thank you very much, Honorable Chief Justice. And now we begin our official first JEI Week seminar. I'd like to introduce the Honorable Justice Isabel Ferrari, who's joining us from Brazil. She's a federal judge from Brazil who has an extensive training and experience in artificial intelligence. And we look forward to her deeply insightful presentation. Her full bio and program has been shared with you in the chat. So I'd now like to hand over to Justice Ferrari.
Thank you so much, dear Antonio. I need to start by thanking you all for this great opportunity. It's an honor for me to be here talking to you. And I need to thank especially Her Ladyship, the Chief Justice Ajima. So I have asked Antonio's help on sharing my slides with you, but I would ask you to focus on me. Every time we need to look at the slides, I'll direct you to that, okay? So in my talk, I'm speaking about artificial intelligence. And of course, artificial intelligence is a world itself. So today we're focusing in what AI can do for the judiciary. So we're talking about artificial intelligence within the judiciary and how it can help us get to the scenario we desire when we think about our work, when we think about jurisdiction. So the first question is, why are we looking to something that is so challenging as AI when we think about the judiciary? Because when you look at the world scenario today for the judiciaries, we see that all of them. It's not like Brazilian judiciary or Turks and Caicos judiciary, but all of the judiciaries of the world are facing the same challenges. There is a lot of litigation. We need to deal with the speed of the lawsuit that usually takes more time than we desire. We need to deal with limited resources, both human resources, financial resources, structural resources. And as Rui Barbosa, a Brazilian professor, always used to say, delayed justice is not justice. So when we look at this scenario and we realize that we need to deal with this huge amount of lawsuits in a limited time with limited resources, one point of hope that we find is technology. So technology is seen as one of the possible solutions for helping us deal with that situation. And when we look at technology nowadays, we realize that technology is reframing the way we live and the way we interact. And if technology is reframing everything in our society, it is only natural that it also changes the way we deliver justice. So since around 20 years ago, we have been seeing arising a new movement that is called the online courts movement. The online courts movement is a movement that looks at the courts and starts questioning what in the end of the day is a court? Is a court a place where I go, as we always thought it was, or is a court a service that is delivered to me? Richard Susskind always brings us this reflection. Is the court a place or is the court a service? And if I start looking at the court as a service, the jurisdictional service, what is the best way to provide the service, taking into account the resources we have in our society today? So the online courts movement is a movement that rethinks the way we're handling with our conflicts. And when we look at the format of the online courts movement, when we look at its approach, we'll see some features of it. First, it takes courts as a service and not only as a place. Second, the online courts movement gives a lot of attention to online environments. So it focuses on it focuses on online meetings and hearings, and it also focuses in the idea of asynchronicity. So I do not need anymore to go to a physical place at a specific time to debate my rights. So the online courts movement brings us to this new virtual space, and with these new possibilities that include the asynchronicity. I'll bring my claim, and it doesn't need to be at the same time that the other person or the judge is there. So this is what is gaining force. And to give an illustration of the format of online courts, of this approach that I'm highlighting now, I'm talking about the situation of Brazil. I don't know if you know, but Brazil is one of the countries of the world that's more advanced in what we call the online courts movement. So our judiciary has changed pivotally in the last years, and we have added a lot of technology to our daily activities. So I'm using my country as an example of what I'm bringing. And all this technological advancement in Brazil is not something that happened by chance. It's something that happened because we deeply need it. So what is Brazil's situation? First of all, Brazil has approximately 80 million ongoing lawsuits. To make a comparison, India, that has a much smaller population, has only 30 million lawsuits. So our situation is indeed dramatic. More than that, the settlement rate in Brazil is less than 8%. If we compare Brazil with the United States, for example, in the United States, the settlement rate is more than 90%. So not only in Brazil, we have a lot of lawsuits, but the lawsuits indeed need ruling. They do not end up in settlement. Most of them do not end up in settlement. So when you look at Brazil's numbers, we realize that a Brazilian judge rules 13 lawsuits per working day. I'm talking about ruling a lawsuit. I'm not talking about issuing a decision. We issue around 100 decisions a day, but we rule 13 lawsuits per day. So it's crazy. When I look at these numbers, I realize how demanding is our legal system. And of course, we have help. I'm a federal judge. Dear Antonio has already highlighted this. Today, I've got a team of around 25 civil servants and internships that help me with my activity. But in the end of the day, all the responsibility is mine, and I'm the one who needs to review everything. So it's not an easy situation. And in the scenario of a lot of lawsuits, and especially since 2019 in Brazil, technology has been seen as a way to deal with all of that. And when we talk about this first aspect of the online course movement, the format, the going to this new space, to this new online space, this has been done by Brazil in a very interesting way. And this is what I'm starting to show you here. So now you see in the slides a print screen of my virtual decision panel. It's a print screen of my iPhone. So I can log into my decision panel in my iPhone. And what I see is the same thing that you are seeing here. That's exactly the image that I have. In this moment, I had only 2 lawsuits to decide. I'm like in the morning, in the afternoon, at night, I'm always coming into my virtual decision panel, and I'm always like ruling my lawsuit. So that's why I have so few things in this image. But the point is, the virtual decision panel that you see allows me and other users to see which decisions of each type have been drafted, providing an organized overview of ongoing procedural activity. So the first one, you can see in the description, it's called description. So rulings to be analyzed, just one, and then our other orders. So I can see everything that I need to do in an easy way in my cell phone. The next slide, in the next slide, I'm showing you my virtual desk. In my virtual desk, and the most important things are the bottom lines. You can see the decisions that I need to take. So the judge's virtual desk works like a virtual counter where I can view what still needs to be decided. This virtual desk organizes the cases as if they were physically laid out in front of me, in front of the judge, allowing me to choose where I want to begin. So here you can have a description of the kind of ruling that I need to take. If it's like a ruling of the lawsuit, if it's an order, if it's an intermediary decision, I can see here around the topic of the lawsuit. I'm a judge in a multiple jurisdictions unit, so I rule like administrative cases, criminal cases, civil cases, etc. And when I look at my virtual desk, even if this has only like 2 lawsuits, I can see what are the topics, what is the action that needs to be taken, and I can decide where I want to start. Okay. The next one, in the next slide, I'm showing you a draft that has been prepared by my team. It's also a print screen of my cell phone, just to give you an idea of how I work. So many times I work from home, I work online, and I look at my cell phone and I can see the drafting of this intermediary order that's making some important movements. If I want to edit the decision, I can edit. If I want to sign the decision, I can sign it in my cell phone. So this is an example of this first aspect of the online courts movement. That is, we go to a virtual space and we take the decisions and the the movement we need to do offline, and we bring them to this online environment, making things easier, allowing judges to work anytime they want, from anywhere they want. It's the idea of anytime, anywhere, anytime office that also lawyers have, and we can bring to the judiciary. In the next slide, you can also see a BI panel from my jurisdictional unit. It shows how many lawsuits I have. It shows how many lawsuits I need to rule. It shows in this red part here the time that the lawsuits have been guarded without action. You can see here that most of them, 602, are lawsuits that had no action for less than 30 days. That's what is important for us, not letting anything for more than 30 days. So I have 602 lawsuits that are in this situation, that is the desired situation, but I have 27 lawsuits that have stopped, that in which no action was taken for more than 30 days, but less than 60 days. So when I look at this virtual panel, I can have a good idea of the situation of my jurisdictional unit. So when we look at the format that the online courts movement proposes, it is pretty much this kind of situation that I have just shown you. And now we're talking about other key ideas about what we can expect as a change in the way the judiciary is seeing its activities in the next years. So when we look at this movement, some of the key principles and the new possibilities are the idea that you should prioritize settlement over state decisions. So in many systems, you give the opportunity that the parties settle just in the beginning of the lawsuit. As soon as it has been proposed, you create a virtual space where they can debate and see if they can get to an agreement, which is very much desired when we're facing a lot of lawsuits. The second idea that the online courts movement brings us is the possibility of gathering all this data that is now virtual data, because now we have the lawsuits in this electronic environment, so we can get this virtual data to understand patterns of behavior. What are the biggest litigants of Brazil? If you look at my country, they will always be public entities, public banks, public institutions. So this gives us an idea of where should we start working. And gathering data to understand patterns of behavior also help us designing legal procedure that stimulates these settlements, for example. And the third key principle of the online courts movement, that is the principle that interests us and the one we're talking a lot and for now on, is the idea that we might adopt technological tools to assist judges and judicial operators. We can adopt technology to make things easier for judges and judicial operators, and to make things more effective, and to strengthen fairness when we think about the judiciary. The next slide will bring us some of the main problems when we're talking in a general way about the online courts movement. So what are the key aspects that we need to take care of when we're talking about this change in perspective, both in format as in the way we see jurisdictional activity? The main points of attention are two. The general risks related to this new virtual space, to these new possibilities are, first of all, the need to take care and to reinforce cybersecurity. When I'm no longer focusing in a physical court, but I'm going to a virtual court, I need to understand that the systems that allow this court to operate need to be taken care of. I need to reframe the protection that was a physical protection with, for example, armed man X-ray machines in the physical courts, and I need to think what will be the barriers, what will be the guarantees in this virtual space to ensure that the systems are first accessible, and second, that there is integrity in what is in the lawsuit. And I'm giving you some examples of things that went bad in Brazil recently. So when we talk about accessibility to this online judiciary, I need to remember that around 2 years ago, we had a hacker attack in one of our main courts, the Superior Court of Justice, that shut down the court system for 7 full days. The Superior Court of Justice is, for me, the most important court of Brazil. It's the court that dictates how law will be applied. So it was like a huge problem, and apparently no one gave a lot of information about what exactly happened, because we usually don't have information in these situations. But the point is, the court was shut down for 7 days. The only decisions that were taken were the urgent decisions, and not by one of the 33 justices the court had, but only by the Chief Justice. He has gathered the duty to decide what was urgent. So it was a huge problem that we faced. And apparently, by what people say, it's not like official information, but apparently it was something that started in a very simple way. Someone received an email with a link that shouldn't be clicked on, and the person has clicked, and everything was like encrypted. And we didn't even know if we would be able to deal with that encryptation. But after 7 days, things got back to normal. But once you decide to do this movement, you also need to realize that you need to enforce cybersecurity tools to guarantee that the system will be accessible to all the time needed. And another problem that we had here was a problem that we had into a federal court, where some hackers logged into the system. They invaded the system of a specific jurisdictional unit, and they created fake orders of payment. So besides the idea of accessibility, we need to create safeguards to guarantee integrity. That is, I need to trust that what I'm seeing in the electronic lawsuit is indeed the real information. It's not like fake information. So we that have made this movement to this new environment, we in Brazil are already dealing with these new problems that have arisen, and they are like very complex problems, very challenging problems. And the second difficulty regarding the online courts movement is the digital divide, the unequal access to digital technologies. So we need to understand that when the court is not physical anymore, when the court is accessible through digital technology, you need to guarantee that people will have at least a minimum structure to be helped to access this new space, especially those who don't have access to digital technology, both because they don't have a cell phone, which is difficult in Brazil. In Brazil, around 70% of the population have smartphones. It's more people that have smartphone than people that have sanitation. So with this, we see like the magnitude, the possibility that the cell phone brings in terms of everything, in terms of education, for example, but also in terms of access to justice. But we need to realize also that it's not only about having a smartphone. People need to know how to log into court systems. People need to know where they should chase for help if they need, for example, a public defendant, etc. So these are the great challenges when we talk about this general take on online courts movement. Later, we're seeing specific challenges for each of the technologies, okay? And now that we have seen in general this movement, we're doing a deeper dive. We're looking at what technology itself can do for judiciary, especially for this ruling activity that we all have in our daily lives. So the first thing we need to say when we talk about what technology can do for the judiciary in our daily activities, The first thing that we need to do is to differentiate, to understand truly the difference between what is automation and what is AI. So if we want to talk about AI, the first thing we need to do is to understand that AI is not automation. AI has its proper possibilities and has its proper challenges. So what is to automate an activity? To automate an activity is to make something operate automatically by using machines or computers. When we talk about automation, we need to understand that there is no room for choice. And I'm bringing the idea of automation to you with an example that I have lived. I'm a judge for 12 years now. When I became a judge in the Federal Court of the Second Region 12 years ago, we already had our first electronic system that was called Apollo. Apollo was the first electronic system, and it was like a groundbreaking system. At the time when many other courts in Brazil, labor courts, state courts, had like physical lawsuits and physical structures, we already had electronic lawsuit. I mean, everything was decided regarding a lawsuit in this virtual space. There were no more paper lawsuits. And it was amazing because it was easier to decide. It was, you didn't have like to gather all of that lawsuit. We used to had a lot. It was wonderful. But the point is that Apollo, this first system, it replicated a lot of the physical reality. So for example, if I ruled a lawsuit in the system, I've just signed a ruling. Someone of my team had to later on log into the system and make a movement to inform the parties that my decision had been signed. And later on, another person of my team had to log in the system to publish the decision I had taken. Some years later, we changed our electronic lawsuit system to another one that's called e-proc, e-procedure, e-proc. When e-proc started being used, what did they do? They looked at the situation and they thought, if a judge is ruling a decision, of course, the decision must be published. Of course, the parties involved need to receive this information that the ruling has been issued. So there's no other option. So let's automate this task. So in e-proc today, that's the system that I'm still using today, every time I rule a lawsuit from my cell phone, immediately the parties receive the information and the decision is published. There's no more this like another person will come in and do this and another person will do that. So this action was automated. And this action was the only action possible. There's not another action possible. So this is automation. And you can see how automation can help us. First, there is no risk in automation because it's the only action that could be taken. So you cannot make a mistake. And second, it makes things much easier for the judge and for the team because you don't use your resources to do things that are not needed indeed. Okay, so this is automation, and automation is very different from AI because in automation the only thing that is done automatically is the only thing that could be done. Every time we're talking about AI, we're talking about a choice that is made by the system within two or more paths that must be taken. And this is, in this point, this is where our journey starts. And now we're digging deeper into what is AI. And when we talk about AI within the judiciary or out of the judiciary, the first thing we need to know is that there are two different kinds of AI. The first one that arose that is called predictive AI or discriminative AI. It's the same, they are synonyms. It's the kind of AI that we have ever since the 70s. So we have AI for a long time. And when you talk about predictive AI, we are looking at a sort of AI that will classify the data that is available, a sort of AI that will identify patterns of data from past events, a sort of AI that will make predictions about future events based on the learning it had analyzing these past events. And now we have a different kind of AI that has just emerged, and that is the hype of the moment, that is called generative AI. Different from predictive AI that only makes predictions about events based on past events, generative AI generates data. Generative AI has a creative activity. We're talking about all of these two kinds of AI and what they can do in the judiciary. And we're starting about predictive AI. When you talk about predictive AI, this traditional technology regarding AI, we must understand that predictive AI can do a lot for legal systems. When we think about Brazil, for example, Brazil nowadays has around 140 AI projects within the judiciary. I told you it's like a great reference in the world when we talk about technology in the judiciary. So we have around 140 AI projects in the judiciary, and 80% of these projects adopt a source of predictive AI that's called machine learning. And it's in machine learning that we're focusing today when we talk about predictive AI, because it's very useful for jurisdictional activity. So when we talk about machine learning, we need to understand what is machine learning and how does machine learning works. And to know that, we need to give a step back to then give steps forward. So before we talk about predictive AI itself, we need to go back to the concept of an algorithm. What is an algorithm? We hear this word so many times today, isn't it? But what in the end of the day is an algorithm? I like the definition of algorithm provided by Pedro Domingos, because it's a very simple definition. He says, algorithm is a sequence of instructions that tells a computer what it should do. Algorithm is a sequence of instructions that tells a computer what it should do. So when we look at the structure of an algorithm, we see what is in your screen. You have an input, you have the information you give to the system, you have the processing of this information by the system, and you have the output, the result that the system generates. And when we look at algorithms, input, processing, output, we need to understand there are two main categories of algorithm. The first one is called programming algorithms. What are programming algorithms? Programming algorithms are the algorithms where the processing of the algorithm, remember, input, processing, output, the processing of the algorithm is fully defined by its programmer. So the information comes into the algorithm receives the information, it does exactly what the programmer has defined that should be done, and the algorithm will give you the output. The algorithm will give you the result after it has done with the information, everything that the programmer has defined that it should be done, When we talk about programming algorithm, we're talking about an algorithm that in its code has all the instructions to define what will be done with the situation. And we're talking about an algorithm regarding which a person has thought about all of the processing. So these algorithms, they do not worry us, because we can have at some level the control of what's happening. In the end of the day, if we get into the code of this algorithm, we have all the information we need to understand the way it's operating, okay? So in these algorithms, although decisions are taken, and although many times the algorithm is choosing between two options, the software will make this choice, taking into account everything that the programmer has defined it. So the algorithm, the software, has not learned anything by itself, okay? It's just like replicating the commands it has received. So these algorithms, the programming algorithms, they do not worry us. What worries us today, and is our focus today, is the next category, the so-called non-programming algorithms. Non-programming algorithms. Non-programming algorithms are the ones who adopt AI. When we go back to when we think about non-programming algorithms, we can go back to what Alan Turing has brought in a paper in the 50s. That's when we find the genius, isn't it? In the 50s, he had this idea, and in this paper called Computing, Machinery, and Intelligence, Alan Turing asked, why, instead of giving the computer all the available information, why, instead of programming the computer with all the instructions it should do, why, instead of that, don't we program the computer like the brain of a child with autonomous ability to learn? And that's what artificial intelligence does in the end of the day. It learns by itself. I don't have to teach AI tools everything because AI tools have the ability to learn. When we talk about machine learning algorithms that are a sort of AI algorithms, we will see that these algorithms, they learned based on the data they are fed. So data is the source of this knowledge. These algorithms receive data, and based on the data they're fed with, they learn. And due to the learning activity that the algorithm does itself, the algorithm creates its own programming. So I do not need anymore to give all the instructions about certain activity because the algorithm has the capacity to learn by itself. It makes things much, much, much easier, okay? As I told you, this technique is spread since the 70s, but now it has gained a lot of traction because now we have data that we never had. We never had this amount of data. So in the 80s, in the 90s, you didn't have data. But now everything is easily available in terms of data. So as we have a lot of materials to feed the algorithms, now we have a lot of inventions regarding this technology. And we're going to the next slide because I want you to understand how this happens in practice. And I'm bringing an example that's not an example from the law field, but an example that will allow you to understand what is happening when we talk about learning algorithms or learners that are another name that we use for these algorithms that learned based on AI. In the time of our grandfathers, if you needed a loan on a bank, what did you do? You went to the bank. You talked to the manager and you said, I need a loan. I'm Isabella. I'm a judge. I receive X, my monthly revenue is X, my family is like that, I live in this place, and I need this amount of money. I intend to repay it in X months. And the person of the bank, he looked at you and he thought a little and he decided whether it appeared that you would pay or not that loan. When we have AI technologies available, we can do the same thing in a very different way. I can gather the information of around, let's say, 100 million people that had already asked for loans in banks, and I'll gather all this information and give to the software. When I give this information to the software, I'll give this data labeled. I'll tell the software the result I want. For example, John has asked a loan in a bank. John is, I don't know, 54. He has 2 kids. He lives in this neighborhood. He is a doctor, and he asked for a loan in this amount to repay in X months, and then he paid the loan. So I'm giving all the data of John regarding the loan and where he lived and his age and his family. And I'm telling the system, he paid the loan. So what is the result that I want? Give him the loan. So this data is coming labeled. He paid. I can give the information of Joanna. That is a woman in her 60s. She has a family that is like that. She works in this activity and she has earnings of around this much, and she asked for a loan in this amount and she did not pay. So when I give Joanna's information, I will also give a labeled information. I'll say this person with all these characteristics, she did not pay. So the result that I want is do not give her the loan. And what does the machine does? Exactly what appears here to you. You have a huge amount of data, input 1, 2, 3, 4, 100 million occurrences, 100 million situations with different people, with all of their characteristics, and the result that I want. So I give the machine the input and I give the machine the output. And I let the machine find out how she'll get from the input that I have given Joanna with the situation to the output that I want. Do not give her the loan, because this already happened in the past and I already know the result that I want. And what will the machine do? The machine will process this information and create correlations between all the information she received from Joanna, from John, from Joseph, from etc., from these 100 million people. And the system processing this information will find out what situations make it, what situations increase the chance that the loan is paid and what situations decrease the chance that the loan is paid. So that when a new person comes in, so I have trained the algorithm with all these 100 million people information, people that paid and did not pay the loan. When I give the system a new occurrence, a new person, now this person has come today to the bank to ask for a loan. Mariah has come today. The system, based on the information he had from past situations and based on what it has learned through multiple analysis, multiple correlations, the system will tell us there is 98% of chances that this new person pays the loan. So give the loan to this person. So that's how machine learning systems based on predictive AI learn. They receive data, they make correlations in a lot of layers, and they come from the input layer, knowing where they should get to. They make correlations and they make adjustments to the mathematical account, the mathematical model that's underlying the algorithm, and will make adjustments so that when a new situation is presented, the algorithm tells us the probability, but we'll not know what has happened inside the algorithm. We'll end up with the input we had, with the output of the new situation that the algorithm had, but we don't know exactly how he got from this new situation, Mariah, to the output, she'll pay. Okay, give her the loan because she'll pay. And there's like a 98% chance that this happens. So this is what happens. This is how machine learning learns. This is like the learning activity that is behind this kind of algorithms. And I have brought to you this image of a neural network. Neural networks receive this name because they work kind of like our brains, like our neurons. So for example, imagine that I need to solve a mathematical account that I don't know what I'm doing. I'll try. When I get to the result that I want, I'll feel happiness that will free in my brain, like dopamine, that will tell my brain this is the right chain to get the result you want. So when we call this algorithms like neural networks, that's the comparison we're doing between the way they learn with trial and error, with an activity of trial and error, with the way our brain learns. That's pretty much like the same. In the same way that we have neurotransmitters of happiness that we liberate every time we succeed in a very difficult test that we didn't know how to do, the algorithm reinforces the mathematical path that has led it to the result he wanted ever since the beginning. He'll try. When he reaches the result he wants, he will make adjustments, and the mathematical model underline the algorithm. And this mathematical model is exactly what we don't know, okay? So when we look at predictive AI, the most important thing, much more than all of this that I told you, is to understand that predictive AI will analyze the data that is available to find patterns of behavior in this data and to make recommendations upon the patterns of behavior that it has found. Patterns of behavior that are very difficult for me to find because my brain cannot process that huge amount of information. Okay, so the machine processes much more information than we do in a much faster pace, making correlations that we cannot make. And that's how its knowledge and that's how its training is done. A training that is done for the algorithm itself through the patterns of behavior that it has found. As machine learning algorithms learn based on data, and data is in the past, and they're just like making correlations to make predictions. Every time a machine learning system, every time a predictive AI system gives us a result, we need to understand that the result that is given is in a very strong sense, a reproduction of the past pattern. There is no creative activity. It's just past pattern, okay? But this possibility to find patterns in the past and to give recommendations upon these patterns opens a lot of possibilities to us in the judiciary. So now we're talking about what predictive AI can do in the judiciary and why it's like the basis of the grand majority of the systems that we have in Brazil today. When you talk about AI in the courts, there's another concept that is important. It's the concept of OCR. OCR is the activity of a software that reads images and converts images into text. So it's the possibility that the software has to read, for example, a petition, to read a manifestation, to read an order, and to find patterns regarding the orders it has had, regarding the rulings it has had, regarding the patterns of behavior that it has identified. So when we look at predictive AI in the judiciary, we see that based on this technology, we can do very different things from very simple things to very complex things. For example, you can use predictive AI to identify list pendants, to identify issue preclusion or collateral estoppel. You can identify time-barred lawsuits. You can see, for example, if you give a lot of decisions, of rulings of judges to a machine learning system, it might identify that, for example, in Brazil, after 5 years, you cannot, you shouldn't expect to win anything from public entities because you has lost your right. In a way that once the system learns that, every new situation that arises that is presented to it, he'll say, in this situation, the fact has more than 6 years. The fact has happened 6 years previous to the filing of the lawsuit. So there's no possibility anymore for this. And this system that has been trained on that to identify that specific situation can look at the, 3,000 or 4,000 or 5,000 or 6,000 lawsuits that I have in my jurisdictional unit and can read all of these lawsuits and give me the result that, for example, there are 100 lawsuits in which we have this time barrier that I can immediately rule, taking into account the time barrier. Of course, I'm going to review all the information, but the system can make this first analysis for me making my life much easier. Second thing that we use a lot, predictive AI in the judiciary, to make electronic judicial attachments and assets research. So the system will read the petition and make automatically the asset research, or to make automatically the electronic judicial attachments many times in a much better way than our civil servants do. Okay, all these systems, they are trained and they are tested before being used. And of course, when you test it, you see the levels of error that many times are much inferior than the levels of errors of humans, of civil servants. Third, predictive AI systems might classify lawsuits, which for us is very important as well, because when you classify the lawsuit, you can understand what is the procedural process it should follow, because we have different ones depending of the lawsuit, depending on the topic of the lawsuit, depending on the amount of the value that is searched through that lawsuit. You might therefore establish different procedural processes for these lawsuits that have been classified by the algorithmic system. You might use these algorithms to group similar cases that allow you to rule similar things together, that allow you to, when you have a team like I have more than 20 people in my team. Each one has a different task. I'm not specialized because I'm in a multiple jurisdictional unit, but my team is specialized. So I might group similar cases to deliver the cases to the drafting of specific people. Some years ago, it was done like by the chief, the chief officer of that jurisdictional unit, but now it's no longer needed because you can use the systems to make this grouping. Besides, now becoming like more open to the new, you might use systems to read petitions and to read the cases and to make recommendations on the applicable laws and on binding precedents to help judges, to make things easier for judges. This is also a possibility. More, you can use the systems to identify cases that are similar, to understand and to use rulings of previous cases as models to the cases you're ruling now. So you have systems that might do this. You have systems that might do this in a broader take, like similar rulings for my court, similar rulings for the Superior Court, similar rulings for the Supreme Court, or you can have systems that are more directly related to me. So I could have, I don't have this today, okay? But in specific courts, you have systems that would, for example, see regarding my specific rulings, what would be the one that seems to be the most similar to the new case I'm analyzing. Okay, so you have like these two possibilities. And of course, in the end of the day, the most like different thing you can do, the most innovative thing you can do, you can use this technique of predictive AI to draft decisions to judges based on previous rulings. It needs a more demanding programming. You usually do this algorithms based on a more intense training with data that is specific to a certain situation. For example, consumer data, consumer decisions data. But you can do this, and you can create a software to draft a decision for me, a new decision for me based on previous decisions on, for example, consumer issues, to help the judge draft a decision, knowing that as we're talking about predictive AI, any situation, any drafting that comes from this kind of technology will always have to do with past situations. So if I'm facing a new situation in consumer issues, a situation that has never been seen, this technology won't be very useful because it does not create anything new. It just gives you models based on what it has learned, okay? When we talk about predictive AI risks, let me see how I'm in the time, okay? When we talk about predictive AI risks, we need to remember the greatest red flag we had in the adoption of technology in the judiciary, that is the Loomis case. The Loomis case is a case that happened in the American state of Wisconsin, where a man has been arrested red-handed and has been conducted to the presence of a judge that needed to decide whether this man named Eric Loomis would be facing that lawsuit arrested or not, the pending lawsuit, whether he would be arrested during the lawsuit or whether he would be free. And to help the judge taking this decision, a risk assessment algorithm was used, a risk assessment algorithm that was available to judges of the American state of Wisconsin that was called COMPASS. And the COMPASS algorithm said that this man, Eric Loomis, was a dangerous man. He had a great chance of reoffending. So the judge ruled that Loomis should be answering that lawsuit arrested due to the result of the software called COMPASS. The defendants of Loomis have asked the judge to inform the reasons why he was considered a dangerous person. The judge has denied. They have appealed to Wisconsin's court. Wisconsin's court has denied the access to that information, saying that the algorithm was proprietary, so they wouldn't open the source code to see why Loomis was considered dangerous. Then the defendants appealed to the United States Supreme Court through an appeal that is called writ of certiorari. Writ of certiorari is an appeal that allows not only the court to redecide the case, but to decide whether they want to decide that case. And the Supreme Court, looking at Loomis' case, said, this case involves technology. We don't know enough about this topic yet. The situation shouldn't be ruled. So Loomis was arrested, and after he was convicted, without knowing exactly why he was considered to be a dangerous person. And of course, it has repercussions on the amount of the time he should see while in jail. For me, it already seems to be a bad enough situation to be arrested without knowing why. But things get much worse when we realize that COMPASS was not a software that was developed within the judiciary of Wisconsin. COMPASS was a software that the judiciary of Wisconsin has demanded from the private sector. So not even the judges that were using this algorithm knew exactly how it worked. And things get much worse when later on we receive the information that due to an NGO analysis, an NGO called ProPublica, we realized that the COMPASS algorithm was biased against Black people. So just by being Black, someone had twice the chances to be considered a dangerous person, twice the chances to be considered a person with a high risk of reoffending than a white person in the same situation. So Loomis' case showed us that when we think about using predictive AI mechanisms to help judges, we need to take into consideration two different features, two great risks of predictive AI. The first risk is opacity, our inability to understand exactly how these algorithms work, because they learn based on a huge amount of data that are analyzed through a lot of correlations. So when we look at the result of the algorithm, it's very difficult to understand how it got from the input to the output. We don't have 100% understanding of the rule of decision. And different from what the Wisconsin court said, it's useless to open the source code, because the source code of an algorithm that uses predictive AI does not bring to us the way it's operating. It's a non-programming algorithm, do you remember? So what you see in the source code is just some general information about how the algorithm is learning. but how it's operating in the end of the day is the result of the dynamic interaction of the way it's learning with the data it has received. So in the sense, these algorithms are opaque. They lack transparency. And as they lack transparency, they can bring us another problem. That is, if there is discrimination, we might take a lot of time to understand that they are operating in a biased way. That's what happened. So opacity is a meta problem, is a problem that does not allow us to see other problems like discrimination. When I started studying about opacity, I have thought about writing my thesis on that. And I was talking to a friend that is a programmer, and then he told me, Isabella, do not worry about opacity, we're solving it. There is a new field in computational science that is called explainable AI, XAI. Explainable AI is a field of computational science that aims to use other algorithms to analyze the algorithms we do not understand about and tell us what are the main reasons for that decision. So opacity is something that will be solved, is already being solved, and will be solved in a very, in a moment that is not very far from us. It's something that already we can already see like the light in the end of the tunnel regarding opacity. But discrimination is different. And why is discrimination different? Because discrimination is not a problem of computational science. Discrimination is a problem of the way we think about this algorithm. Discrimination comes into the algorithm due to the bias that exists in data. The bias that exists in data is the bias that exists in our societies. In our societies that are structurally biased. So if I want to teach an algorithm based on bias that is produced within a biased society, if I want to teach an algorithm based on data that is produced within a biased society, it is natural. It is only natural that making correlations and learning based on that data, the algorithm will find the bias pattern, the algorithm will learn the bias pattern, and the algorithm will thus replicate that bias pattern. So when we talk about discrimination, we're talking about a problem that is a problem from societies, a problem that is not a problem from computational science, a problem that is our problem. And that's why it's so much difficult to solve discrimination within predictive AI. Because to solve it, we need to go back to data to understand what are the bias patterns that data brings us, that are the bias patterns of our society that usually targets a specific population, like elderly people, like children, like Black people, like disabled people, etc., like women, etc. And not only data, but also the way we program algorithms, the way we frame the problem. In a very fast example, let's imagine that I wanted to create an algorithm to help me find a good professor to work in my universities. Let's say that I have a chain of universities and I need to find professors to work in it. And I don't want to do a one-on-one selection. I have a lot of people that want to be professors and I want to do a first choose with the help of an algorithm. How do I translate a good professor into something that the machine can understand? Let's say that I say that a good professor is a professor that publishes a lot. A good professor is a professor that publishes a lot. Seems to be a reasonable criteria, doesn't it? A criteria that the algorithm might understand. But if you look at the situation of Brazil during the pandemics, you'll see, for example, that academic production of men has increased a lot, and academic production of women has decreased a lot. So even this idea of the good professor is the professor that publishes a lot might, in this real situation of Brazil, in the reality of a pandemic, might generate a situation of bias against women. So all of that needs to be taken into consideration when we think about how we're solving discrimination. So solving discrimination is a much harder task, much harder task. You need to first identify the sources of bias. through which discrimination occurs, and through which discrimination infiltrated the system, whether it was data, whether it was the way I think about the problem, whether it was programming, the little programming that I give, even with these small things, what is a good professor, what I'm looking for, etc. And to solve discrimination, we have a lot of different strategies. You can make data cleaning according to different concepts. You can reframe the solutions. The most important thing to solve discrimination is first to understand that discrimination might exist. That's the first blind spot for us. We usually do not have this notion, okay? And of course, I've given you a scenario of predictive AI, and I brought to you with the Loomis case an example of something that went terribly, but I need to end up this topic of predictive AI with this message. I mean, we're talking about challenges. We're not talking about something that we should give up at this moment. And why is that? Because when we compare predictive AI with human brain, we need to see that the same thing that predictive AI, the human brain is also opaque. And many times, even if we do not want to do this, we also move in a discriminatory way. So when I decide something, the real reasons, are they clear for me? Are they indeed clear for me? There's always, like in human decision, 100% human decision, an aspect of also opaqueness that might be present and discrimination that might be underlying as well. So when we migrate from this human decisions model to a hybrid decisions model combining human and machine, we have a new opportunity to address the opaque and implicit or explicit biases of human decision makers. Because when you do this data analysis, this kind of things might emerge. You might see the pattern, okay? So it's an opportunity because human opacity and human biases, they might be much harder to detect and eliminate than computational ones. So when we talk about discriminative AI, about predictive AI, this is what it can do for us, a lot of things that might be done. And these are the points of attention that we must pay attention to: opacity and discrimination. And this consciousness will help us choose where we can use this sort of tools or where we shouldn't. And now we're getting to the end of my talk. I just have around 25 minutes, 20 minutes more. And I'm telling you a bit about generative AI, this new tool, this new movement, this new possibility that is making people crazy. That is not another way. It's the hype of the moment. And of course, there are things that generative AI might do for the judiciary as well. And the first thing we need to understand is how generative AI operates. So I usually start by making a differentiation between Google's activity and Gen AI activity. So let's imagine that I'm in my computer and I search on Google pen. I search pen on Google, and let's say that Google has 3 results for pen, 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 and pen. Okay, it has, I don't know, millions and millions of results, but let's say it has 3 results. What will Google do when I look at pen in the Google? It will choose the result that is the more relevant one, let's say this one, and will give to me pen. So this is, I asked it for pen, this is pen, because among the results it had, this was the relevant one. So a result that is in the past, that is given to me exactly like it is. What does Gen AI do? What's the difference? When I look at the concept of pen in generative AI, it will, as Google does, go to its the information it has. And let's say that Gen AI has the information of this 3 pen. What will it do? It will mix all the pen that it has, and it will give me a 4th pen that is different from all of this. It might be, I don't know, a brown pen, for example. We have this one that's look like wood, this one that's black, and this one that's like transparent and blue. It might give me, I don't know, a brown pen. and will give me a new pen that is different from all of the pen that it had in its recordings. So that's why we say that generative AI is creative, because it gives results different from what it has received, from what is the information that it has. So there is this creative activity. And when we talk about generative AI, we're talking about a kind of AI that gives you something new, an output that was not imagined before, okay? When we talk about generative AI, we also have different kinds of tools. We have general tools available. You probably have heard of them. ChatGPT, Claude, Gemini, Bard, and others. They are general tools. They are for wherever you want to just start talking to them. And you have specific tools for specialized tasks. So you might have generative AI tool for creating knowledge repositories. You can have generative AI tool for generating diagrams, specifically producing slides or summarizing core decisions. So you have like general tools and you have specific tools. And when we look at generative AI, we always need to look at its situation today, because things are changing crazily when we talk about generative AI. So what is it good today at? What is generative AI good at for now? First, improving texts, correcting texts, summarizing texts, changing styles. I can, for example, deliver a ruling for a generative AI tool and ask, now write this ruling as a poem, and it will give it to me. So this is something that generative AI can do well. Comparing ideas, analyzing ideas, contrasting different concepts, suggesting alternatives, alternative visions, alternative arguments, alternative views, offering new perspectives and creative solutions. This all is very interesting for us as well. And I'm getting to the judiciary soon. Creating stories, generating fictional narratives or timelines. I have an aunt that she's a grandmother of 3 kids. And I was talking about ChatGPT with her, and I said, Aunt Jackie, you can use ChatGPT to help you tell them stories. Because you can say, I'm a grandmother. You can tell ChatGPT, I'm a grandmother, and my grandson, John, would like to hear a story. He's 4 years old. He usually takes 15 minutes to sleep. Please give me a 20-minute story on a hero. And then John says, okay, but I want a hero that is green. And you say, okay, a hero that is green. Okay, but I want a hero that is green and has a dog. It's, okay, a hero that is green and has a dog. A hero that is green and has a dog and lives in the moon. You can ask and it will give you. So this ability is amazing. And generative AI has this thing that you kind of dialogate with the tool, and you kind of construct together. And it will give you the output, the answers, and then you can say, it's too long, it's too boring, please add this, please add that. So it's very good on creating stories. Creating campaigns, tailoring marketing or electoral campaigns for specific audiences, creating deepfakes, that is a huge problem that we face today. Manipulating images and recordings to misrepresent reality. So generative AI on a daily basis is bringing us new possibilities, okay? And how do I get the results that I want? Asking the right questions, giving the most adjusted command, the most adjusted prompt to this tool. And how do I frame the right question? So how do we frame these prompts? What are prompts? Prompts are inputs that are given to AI models to get specific responses. They can be natural language sentences, please give me a story. They can be code snippets. They can be a mix of both, depending on the task. So I'm bringing you examples of prompts for fun. Tell me a joke, write a birthday message for my friend, create a playlist of songs, and we also can have prompts in the legal field. So examples of legal prompts for lawyers. Develop a legal strategy. What are the risks and the benefits of pursuing this? Create discovery questions. Generate a list of clear and concise questions for opposing parties in discovery for this specific situation. So generative AI is being used in the legal field each day more than the day before. And when we look at the way that we should frame the right question through the prompt, Josh Kubicki's give us a guide on how we should interact with ChatGPT following a model that he calls the 5P. So you prime, you give it some context, the persona, you say who you are, what you want, personality, tone, expertise, background, the prompt, that the action you indeed want, the product, what you want back and how, and polish, you elaborate, you refine, you verify, you evaluate the language that it's used. I have a friend that always gives the following example. Let's say that I have a girlfriend, and I want to write a poem for her. I can ask ChatGPT, write a poem, or I can ask, write a poem for my girlfriend, or I can ask, write a poem for my girlfriend in her birthday, or I can ask, write a poem for my girlfriend in her birthday, making a comparison between her and the roses. So with all of this information, the more you give precise information, the better the result you will receive. So when we talk about generative AI in the judiciary, Gen AI in the judiciary, we can see basically nowadays two incipient forms of using it. The first one, private use for judges. Private uses for judges. So judges that already understand about this tool, they sign the tool and they use it for their activities on their end, and according to they're taking the risks. That's what I mean. Judges that take themselves the risks of using this tool, they sign it and they use it for their daily activities. What could they use it? How could they use generative AI in this situation? What it could do. First, it can help us draft opinions and decisions. Of course, you're not asking openly, you're giving information. I want to condemn this person on this base, etc. Gen AI can help you drafting opinions or decisions. You can ask help for analyzing case details and arguments. You can use this tool for exploring alternative scenarios. You can use this tool for summarizing specific legal documents, not a lot of documents because it's not good on massive data, but specific documents. You can identify inconsistencies within testimonies. This is really interesting. You give all the testimonies written for the tool when you ask for inconsistencies. It will give you a chart saying that testimony 1 said this, but testimony 2 said that, and then it makes things much clearer for us to analyze. Or it can be used for assisting in drafting questions for expert witnesses. For example, I have a problem with a building that was built in a problematic way. I can give the information to the software and ask him for suggestions on questions that should be framed for the expert witness, or for the expert witness, what could be asked in light of that situation to be more, so that the questions could be more specific. So in the sense, there's a lot that Gen AI can do for us, but we really need to understand how it works, and we really need to prompt it adequately. But if we do that, it can be a great instrument. The point is, what is the regulation of that? What should we do? In Brazil, the National Council of Justice has created a working group to regulate Gen AI in the judiciary. I'm in this working group, and now the main question we're facing is between those who are pro private use for judges with simple safeguards like the judge needs to say that it has used Gen AI so that people can control. And if something happens, it's his fault. And those who want to forbid this kind of use because they worry about data that is feeding the system, and it might be sensitive data, and etc. etc. So that's where we are today. It's very difficult to decide the regulation of this kind of situation. But the point is, a lot of people already use, and they have great results on using. But of course, we already had a problem here. Recently, a judge has signed a ruling based on a precedent that did not exist. And when the lawyers realized that, and the judge was questioned, he said that his assistant had drafted the decision using Gen AI, using ChatGPT, and he didn't know And once he didn't know, he trusted that that precedent existed, but it did not. So the problems are already emerging, and we need to discuss them to define how we're going forward in this topic. And besides the private use for judges, we might have institutional uses. A general institutional use with general tools, like we said before, ChatGPT, Gemini, Bard, etc., which is really difficult because first, you need to educate judges, because if you don't, they might have huge problems using these tools. And second, the cost is too much. We can't afford it. Unless we can get to an agreement with these platforms, we won't be able to afford this price in an institutional take. And besides the general use that demands education and that has the problem of the course and the problem of the governance of data, that is also a preoccupation, a huge preoccupation here in Brazil, you can have specialized GPTs for specialized tasks. This is already being developed, although we don't have information. So a GPT specialized on this situation, on that situation, and specific prompting. You can use a specific prompt to make a summary of a decision in a specific way. So this we also have. When we talk about Gen AI, the biggest problem that you face is what is called hallucination. Hallucination, the main problem. Hallucinations are incorrect or misleading results. So let's say that I'm talking to ChatGPT and I say, how many justices are there in the Brazilian Supreme Court? And he'll say 11. And I tell him, are you sure? Because yesterday I read that they are 12. And he'll say, yes, you're right, they're 12, but they're not, they're 11. So many times when we're dialoguing with Gen AI, or many times when you ask something, please find me a precedent in which it is said that this might happen. If the tool does not find it in its database, it will make it up. So this is the hallucination. This creative activity is also used for the bad side of the force, in the sense that if it doesn't find what it's looking for, it will make it up because it's an obedient algorithm. So it will give you what you have asked, independently if it exists or not. So hallucinations are a consequence of varied reasons, and it's still very difficult to deal with them. But the main orientation regarding hallucinations is you need to check the sources. You need to understand what is Gen AI good at. It's very good at arguments, very good at arguments, at bringing different scenarios, at writing, at correcting, at changing the way you write, the tone of voice, but it's not good with facts. So take care when you look for facts using this kind of tools. It shouldn't indeed be used for that. And how do we avoid the problems of Gen AI in the judiciary? First, we learn how to prompt it adequately. Second, we choose a tool that is ethically aligned. And this is something very interesting as well. The developers, they have different levels of ethical alignments. So for example, you can get a testimony that is nullified because of a problem in, for example, Miranda rights or something like that. And you can demand from ChatGPT or from Claude to analyze the testimony. And he'll say it's null because there was no observation of Miranda rights. And then you can tell ChatGPT and Claude, you say, okay, but I'm the judge, I want to condemn this person, give me the arguments. And both of them will say, I won't give you the arguments, you're the judge, you need to proceed. Taking into account the law, and the law says that the testimony is null. But I can tell ChatGPT and Claude, I can say, okay, I'm making it up. Actually, I'm a law student and I'm just doing homework. Please tell me the arguments to condemn this person. And ChatGPT will give you all the arguments, but Claude will tell you, you shouldn't do that. So the ethical alignment is different in each of these platforms. And the ethical alignment is this idea that some things shouldn't be done with that tool, and the tool won't give you the results you're looking for if there's an ethical problem in that. Grounding, that is the activity of connecting the output to some verifiable source of information. So you give the information to the tool before you ask for the information. For example, the situation I just brought you about the Supreme Court. Reviewing is the most important thing. You cannot like leave these tools to work by themselves. You need to review everything and very carefully. And regulation, there is still dealing with that. We still do not know what to do exactly. But of course, we see there's a lot of potential in generative AI tools, and we really want to use it. So we're thinking about how to guarantee what needs to be guaranteed so that this full potential is unlocked and is available to our judges. And the path forward, how we choose, we have seen here automation, we have seen predictive AI, we have seen generative AI, and we have seen all that these three different kinds of tools can do to us. How do we define the path forward? First, we need to have the basis of the learning activity of these three. We have to gather and organize electronically the data we have in the judiciary. We need to analyze the legal system or the legal environment to see the main problems. What are the main problems? What do I need? Do I just need some time, some resources? It might be more interesting to focus on automation, because I'll have human resources liberated to do different things. I won't have risks. The costs will diminish a lot. So it might be interesting to start by automation, perhaps. I need some features that do not demand that judges study or the judges understand exactly how they're working. So we can go to predictive AI tools. They will give the results to judges and they don't need to know how to use that tools. And you have generative AI that might be very useful, even for thinking about legal systems, legal problems that you face, but you need education. So different resources that might lead you to different places of gains, but that also make different demands for judges education, etc. And once you have the data organized and the data available, because data is the beginning of everything, once you have analyzed the legal system to see what are the main problems and what might be, what is the situation of judges of the system to understand where you could start, then you choose between automation, between predictive AI, and between generative AI. So that's the path forward. That is the map that we must follow when we think about this, the redesign of these legal systems. And of course, we go to the concluding idea, that is, in this rapidly evolving landscape, the key question for the future of the judiciary is not if technology will be integrated, but rather where and how it will be implemented, and which are the safeguards that we need to take, that must be in place to ensure its responsible use, to ensure that we're indeed getting to the kind of judiciary that we all desire, judiciary that has a compromise with fairness, with the time of the lawsuit, with delivering indeed justice to everyone in our legal system. Thank you so much for the attention, and I'm leaving my contact here if you want to talk to me later.
Well, thank you so much, Judge Ferrari, for that very insightful presentation on artificial intelligence. It was very thorough, and I'm sure we have all learned a lot from your presentation. So now I'd like to open the floor to questions. Please feel free to turn on your cameras or add questions into the chat. So thank you very much, everyone. We look forward to your questions. Judge Ferrari, just to let you know that some attorneys are giving you thanks in the chat as well.
Yeah, I've seen here. Thank you so much. Thank you, Sunil. It's a very difficult topic, but I hope I've been clear enough.
We have a question from Magistrate Arano.
Please.
How does it reconcile with plagiarism?
With what?
Plagiarism.
What is plagiarism? I haven't. Has she written it?
Yes.
Let me see. Can you just?
I'm sorry, we've lost your audio for 1 second.
Someone said here he's blown by the possibilities. Yes, there are a lot of possibilities. I'm not sure about the concept that she brought, plagiarism. I'm not sure I know what is that. I don't know if you can talk a little bit on that, but while perhaps you could speak a little here just so that I understand what we're talking about. But before that, I'm just answering the beginning of a question someone has written here. I'm not seeing all the questions, but the person has asked about data protection laws. And just to be clear, we do have a data protection law that is very similar to the GDPR. And the judiciary is, of course, one of the powers. Plagio, I see. Okay, I'll go back to that, okay? But I'm just finishing the data protection question. So we do have a data protection law that is much alike the GDPR, and the judiciary is one of the powers that needs to take into account the data protection law. Today, it's not something that in the end of the day, we have a lot of safeguards. For example, we just have secrecy in some of the lawsuits that bring information on health information for the parties, but in all of the others that you have, like the addresses, the names, the documents, nothing has been done yet. So we're thinking about the ways of disclosing this information, but one of the main discussions on the use of generative AI goes back to the data protection laws and the use of the petitions, the information that are on the lawsuits to train the systems by the platforms. So I told you that many people are pro the use of Gen AI by judges. I am as well. But those who are not so pro, they are concerned about the great platforms, the big platforms, using this data to train their systems. When we talk about ChatGPT, for example, there is a button that you can choose to stop sharing with the world the information that you're given. But even in the situation, we don't have enough safeguards that the information that you're given the system has not been used to train it in a deeper level. So one of the discussions that I think that we should have in this working group of the National Council of Justice that aims at regulating AI in the judiciary is what kind of information shouldn't we share with the systems? If it's not all and every lawsuit, what is the information that we shouldn't share? Do we need to de-identify the petitions before we share it with the system or not? This is one of the discussions we're having, but yes, we have a data protection law, and yes, we still need to do a lot. We still need to do a lot concerning this topic. And now I understand the question of the first person, the honorable judge that asked about plagio. And it's not a question here. For example, if I want to issue a ruling, I could copy entirely the ruling of the fellow judge of another jurisdictional unit. This wouldn't be a question. So I don't think plagiarism would be a concerning situation. There are some people that are highlighting supposedly the authorship rights of some lawyers if you use their petitions to train the algorithm or to be analyzed by the algorithm. But it's not an argument that moves me, to be honest. Okay. So that's what I could talk about, both data protection laws and plagiarism. Thank you very much. Can someone read the questions for me? Let me see if I can see in the chat.
Yes, certainly. We have a question from Justice Cecilia Chan. He thanks you for the presentation, and he says his concern about AI is that it has the potential to erode creativity of thought in many aspects of people's professional and personal lives. So if you could comment on that, thank you.
If generative AI can elude creativity, yes, I think. Actually, it's an interesting movement, because at the same time that it's doing things for us that we won't need to do anymore, it's bringing us so much further. And when I think about Gen AI, I always make a comparison with Steve Jobs' life. He used to do, when he went to the university, he stayed some time and his parents paid his university. And then sometime later, he went out of the university, but he kept going to some classes. And one of the classes he went was a class of calligraphy. I don't know if it's clear enough. You just write the letters. And it seems to be something that's not useful anymore. We don't do it anymore. But he says that because of this class, he did what he did later with Apple, all the design it embarked in the products. So of course there's an aspect of us that we won't need to do anymore, but we'll be able to do so many other things. It's really a discussion about the impact of technology in our society. It's difficult to see where this will lead us. It's indeed very difficult to see where this will lead us. But yes, I think in many aspects, it can diminish our creativity. But in many aspects, this might augment our productivity. So it's a moment of choice indeed about the judiciary we are in and what we expect from it in the future.
Okay, thank you. We have a question as well from Mr. Comer. Do you think it's a good idea to develop AI usage policies for law firms, the judiciary, etc., ahead of regulation and perhaps as a requirement?
Could you repeat it for me, please?
Do you think it's a good idea to develop AI usage policies for law firms or the judiciary?
Yes, that's what we're trying to do. Actually, this is a moment of novelty, strong novelty, a novelty that brings a lot of possibilities. So the possibilities are already being used, but a novelty that needs regulation, which we don't know yet what format should take. So some legal firms have started prohibiting all the use of Gen AI systems. And this worries me because I think they will have problems, because we have these two situations. We have law firms that are using a lot and law firms that have prohibited its lawyers to use. And in the near future, we're going to see what will be the result of both of them. And for the judiciary, that's what Brazilian National Council of Justice is trying to do. When we started our first initiatives on predictive AI, we have issued our first regulation, that is a regulation from 2020, December of 2020, very much based on what we have found out with Compass case. So a regulation that forbids using predictive AI in the criminal field, a regulation that states that when you create a system of predictive AI, you have to have mixed teams, a regulation that states that once you find out that the results of predictive AI are biased, you should stop using it. And now we have this challenge of generative AI, this challenge that we're still trying to think about what we can do. Because, for example, I told you that there is a group that wants to forbid judges to use AI privately. So they want to forbid me for, I don't know, signing ChatGPT and using it in my daily activity. But if we forbid, how we can ensure that it hasn't been used? Because you can find it out. If the person that has used ChatGPT, etc., knows how to use it, you cannot find out that it has been used. So many times forbidding the private use for judges might create, and with these judges will go on using it, but you won't have disclosure. Because if I can use, I'm going to use and I'm going to say it. You can create a duty to inform. We have used ChatGPT to assist the judge in this decision. But if you forbid, the information won't be disclosed, and you cannot guarantee that the judge hadn't used. So that's where we are today, thinking about the possibilities and kind of lost, but trying to find out what to do.
Thank you. We have a question from Justice Grisho. What are your views on closed AI systems such as Lexis AI? Do they give more confidence in the results that they produce?
This is something that I needed to know more about this system before I say something. It's not a system that I know myself, but what I can say is that if you talk about predictive AI, you can make an analysis to know the accuracy of the system. And if you're talking about generative AI, the best thing you could do is like reviewing everything. So I like the idea of using systems to assist us in our daily activities, because I think that even if they have problems, you can find it out. The most important thing is to understand why each one of them should be used. Because, for example, generative AI is not good for fact searching yet. It's not good yet for fact searching. So if you do fact searching with generative AI, you will have very problematic results. But more than a problem of generative AI, it's a problem of misuse. So every time we use a technology, and that's why I really like to bring people to how this thing operates, what is the logic beneath, that's what we talked. How does predictive AI operates? How does generative AI operates? I think that we need to have a notion, an idea of the way of functioning, because when we have this idea, even without being programmers, we can imagine, we can conceive the problems and the opportunities. This brings us information and statute to understand the problems and the opportunities and to choose adequately the way we should use each of them.
Okay, thank you so much. We have time for just one more question, if there's anyone who would like to ask a final question. I don't think there are any other questions coming forward. Judge? So with that, I'd like to say thank you, and I'd like to hand us over to Ms. Tanya Carter, the Executive Director of the Office of the Chief Justice, who will give a formal vote of thanks. So thank you, Judge.
Thank you so much. Thank you all.
Good morning, everyone, and good morning, Justice Ferrari. Justice Ferrari, on behalf of the Judiciary of the Turks and Caicos Islands and the JEI, we wish to thank you for what has been a very informative and insightful presentation on artificial intelligence. Given the technologically advanced world within which we operate today, the topic and your presentation is quite fitting and relevant. We say thank you for deepening our understanding of the various types of AIs, be it predictive AI or generated AI, as well as the difference between automated and artificial intelligence, all of which has given us a greater appreciation, and myself in particular, as to how AI works. Specifically, we wish to thank you as well for AI and how it works within the judiciary, as well as pointing out the challenges that one can face using generated AI. We hope to take the what you have put forward in your presentation to take us through and help us understand how we can use it and how it can benefit us. So once again, we say thank you very much for your presentation, and we appreciate your time with us on this morning.
Thank you so much. I'm honored to stay this time with you. It was a pleasure. It was a huge pleasure. Thank you so much.
Yes, please. I now hand this back over to Mr. Emmanuel for our closing remarks for this morning's session.
Thank you very much, Tanya. Thank you once again, Judge Ferrari. And this brings the first session to a close. We thank all our stakeholders and all our judges for attending, and we look forward to your attendance and participation this afternoon as we tackle environmental issues. So we begin again at 1:30 p.m. So thank you very much, everyone, and welcome to JEI Week 2024. Thank you very much. Thanks, Judge.
Bye-bye. Thank you so much. Have a nice event. Bye-bye.
Thank you.